appeal in the matter of St. Patrick International College Limited and Interactive Manchester Limited and HMRC.
Yes, Mr.
Good morning. I was part of the way through rank yesterday.
Yes.
Before I deal with that, can I briefly deal with my Lord Justice Miles's question during the course of the afternoon, and I said I'd come back to it. So if I could just quickly deal with that now. If I can, my recollection of what I was asked was it right, looking at the FTT at 168, that there was no finding there regarding the regulation of colleges of universities as opposed to universities themselves? So the explanation is that there was, the short answer is that is correct. Just to explain the position with colleges of universities, as far as university colleges are concerned, which is a defined term in the UK, there is a higher regulatory regime where a body is formally a university college. So this is rather than college of university in the VAT sense. A university college, and one will see this from the FTT decision at 78 to 79, has to obtain permission from the Privy Council to call itself a university college. And there are also significant good governance criteria to obtain formal university college status, and we'll see that this is in the bundle at 123, the core bundle 123 and 124. So 78 and 79 is the paragraph numbers, and we'll see Judge Cannon explains in 78 and 79 that to call yourself a university college, you need to get permission of the Privy Council. And then over the page 82, paragraph 82 on page 124, there are also significant good governance criteria to obtain formal university college status. I realise that is to be a university college formally is perhaps a subset of being a college of a university for the VAT provision, because that is set out in the SAE test as laid down by the Supreme Court. So it is true that a college of a university in the VAT sense does not necessarily need to be formally a university college in the sense explained in those passages. And you'll see that from, in fact, the FTT on page 140 at paragraph 176. So there, the Judge Cannon says, in my view, the exclusion of the appellants from the exemption does not breach the principle of fiscal neutrality. The regulatory regime for DAPT and university title does not apply to the appellants. As such, they were not in a comparable position to a university or a college of a university, unless it can be said that they are a college of a university, which was the Iman question, which Iman failed on. The point, though, is that it is true that to be a college of a university, you have to pass a slightly different test, which is the SAE test. As the Court of Appeal explained in FBT, Lady Justice Arden, she explained that the UK was entitled to recognise colleges of universities, as well as universities themselves, as having similar objects to bodies governed by public law. And perhaps I can just give the court the relevant reference. It's 54 and 55 at page 370 of the authorities bundle. She stated that in order to be a non-public body which qualifies, there must be a public interest element in its work. It has decided to draw the line in the case of universities to those colleges, halls or schools which are integrated into universities and which are therefore imbued with its objects. So what she was saying there is, in order to qualify as a college of a university, you have to be sufficiently integrated with the university to share and be imbued with the university's objects. And she then said, in the same passages at 54 and 55, for an alternative provider such as in that case FBT, that would require it to say that it belongs to the same class as those institutions which meet the integration test in Note 1b. Going back to 168, it's correct that it's right that there's no finding there regarding the regulations applying to colleges of universities, but what is perhaps shorthand, when it said at 168 that there were no differences between universities and colleges of universities, it wasn't saying that the regulations applying to universities regarding DAPS and university title apply directly to colleges of universities, but what it was saying, it was effectively in shorthand because with the knowledge of the FBT judgment, that there was effectively a second different gateway for colleges of a university. Universities have to comply with DAPS and university title, and colleges of university have to satisfy the SAE test. There is effectively a derivative further test for colleges of university that they must be so closely integrated with universities that they share the same objects. So I hope that explains our position on that. We're not saying that colleges of university have to have DAPS and university title, but universities do, and then colleges of university must establish that they're so closely integrated that they share the same objects applying SAE.
And to take a concrete example, listeners are probably familiar with the collegiate structure of Oxbridge and some other universities, and there it's quite easy to distinguish between the university as a separate charitable body on the one hand, and the individual colleges which are themselves charitable and have their own governing statutes and so forth.
Yes.
But then if you look a bit wider, you get rather more anomalous looking bodies like University College London, which is presumably in that kind of mixed category we're mentioning, where they're really more akin to university in ordinary parlance.
Yes.
And have to get to, say, Privy Council approval and so forth.
Yes. I think the University of Wales, as was, used to be in the same position because some of its colleges are now themselves universities, Cardiff and Swansea and so on.
Didn't know that, thank you.
I'm just wondering though where this goes, because the FTT's point of distinction between the appellants and the university was the regulatory regime which applied to universities.
Right.
In particular, 2 points, the DAPs and the requirements for getting university title. And neither of those applies to a college of a university, as I understand it.
That is true, but there is then a second. If you want to say that you're a college of a university, you have to satisfy the SAE test. 2 of the appellants didn't even attempt that. IMAN did attempt it, but failed. So the appellants cannot say, they can't say that they are comparable to university because they didn't satisfy either university title or DAPS. There is a mechanism for doing that, but they haven't gone through that mechanism.
Can't they say that, I understood them to be saying that they're comparable to a college of a university?
Well, they tried that. One
said it was a college of a university.
And it failed.
They failed on that, but then they say that they're comparable in the sense there being no relevant difference. So they're in a similar position for the purposes of the rules of fiscal neutrality, and that there's no finding that there was a significant regulatory difference in relation to between them and colleges of universities. That's what I understand their argument.
Yes. But the difficulty they've got then is how do they get around or explain what they say then about the Court of Lady Justice Arden in FBT, because she says that the UK was entitled, as well as exempting the supply of education of the relevant types by universities, the UK was entitled to also exempt the same supplies but made by colleges of university, but restricting colleges of university to only to bodies which were so closely integrated into a parent university that they were imbued and shared the objectives of the parent university. So college of university doesn't mean any body which provides university level higher education, but only particular bodies which are integrated into and imbued with the objects of a parent university.
Where do further education colleges fit into this?
Well, they fit into it because effectively there is a separate gateway for them. The question, I think this is my learned friend's point too, was the UK entitled to have a number of different gateways? My learned friends say no, and we say yes. We'll get on to why we say yes later this morning. But the question is, on point two, can you have a series of different gateways to the exemption which apply to particular providers? And we say that that is permissible. But our point is that the fact that colleges of a university aren't required to have DAPS and university college status doesn't mean that there's no requirement in order to be a college of university, because that has been decided by both the Court of Appeal and the Supreme in FBT and by the Supreme Court in SAE. And that's quite a difficult requirement to satisfy, that you're both sufficiently integrated into the parent university and imbued with its objects, as this case demonstrates, because IMAN wasn't, although it could satisfy some of the criteria, on balance, the learned judge decided that IMAN couldn't satisfy the test in relation to either of the two prospective universities, University of Wales and parent universities, and I think the other one was London Metropolitan University. Just while...
Right, sorry, just to complete this point, the FTT didn't make that second point about satisfaction of the SAE test.
Not in 168, I don't think, no. But my learned friend, Miss Inglis, reminds me that the SAE test is quoted. I'll just see if I can...
SAE is quoted at 194 following.
Yes.
And that's in discussing the question whether IMAN was a college of a UK university.
Yes.
Yeah.
So the learned judge, Judge Cannon, did have the SAE test before him. There may have been in 168. There may have been, well, he already knew that he had to deal with the College of a University point when he was dealing with IMAN. So he may have, given that he already knew what he was going to decide in relation to that, he might not have, there's perhaps an element of compression at 168 because he already knew he specifically had to deal with the requirements to be a College of University and whether the one body which claimed to be one, IMAN, satisfied it. While I'm on this theme, I wonder if we could just give a few references just for the court to note down, just as to the significance of the regulatory differences. I don't need to turn them all up, but if I could just give the paragraph numbers, the most relevant ones we say are, as well as 168, 62 and 66 on page 121, 74 on 122, 79 to 82 on 123, and 176 to 177 on page 140. If I may turn back to rank, if now is a good time to do so, please.
Just remind me which tab that was in.
That is at tab 32, page 69,
32.
please. So my first area I wanted just to deal with was just to explain a few points on fiscal neutrality and then go on to the BG and H case law. There are a lot of cases on that, so I might have to canter through to the most relevant bits. But just on the fiscal neutrality points, where I got to yesterday, you'll recall just before we broke at 4:15, I got as far as 23. And what I'd explained was that the whole case was about somewhat arcane distinctions between different types of slot machines and mechanised cash bingo. At least as far as the slot machines were concerned, I think we were just looked at part between 19 and 23, where the Court of Justice explained that the taxation in the UK of the slot machines depended on where the gaming software, which determined whether you won or lost, was. So if it was within the machine, as the rank machines, as was the case with the rank machines, the services provided by the machines were taxable according to the UK, but the UK accepted with the two comparator types of machines, which are explained at 21 and 22, that where the random number generator was outside of the machine, either in some sort of common box within the arcade or perhaps somewhere else, then because the element of chance was outside the machine, the UK accepted that those machines were exempt. But what this goes to is that the whole of the debate about fiscal neutrality in rank was about what was being supplied. The point was that from a consumer's perspective, they neither know nor care if they're playing slot machines, whether they're of one type or the other, where the random number generator lies, whether it's actually inside the housing of the slot machine or in some box in the manager's office. So we say that the whole, given that the case concerned the comparability of the various types of supplies made by these different types of machine, the whole of the court's analysis was focused exclusively on the supply and not the supplier. And therefore, when one looks at 32 to 36, which my learned friends rely on as to the consumer perspective, that focus specifically on the similarity of the supplies. And if one looks at 34 on page 641, particularly on the assessment of whether the supplies were identical or similar for the purposes of fiscal neutrality from the point of the consumer, and meet the same needs of the consumer. But 34, it refers specifically to the supplies of services, and then if the supplies in question are identical or similar from the point of view of the consumer. So what's being discussed here is the supplies and nothing to do with the suppliers. We say that it's understandable that when you're talking about the supply, that you do focus on the consumer perspective, because it's the consumer who is, I suppose to coin a phrase, the judge in this, as far as whether the supply is interchangeable or not. I think to give perhaps a homely analogy, if we're deciding whether consumers, by deciding whether they're prepared to buy something or not, can decide whether a bottle of red wine from France for £7 is akin to a bottle of Malbec from Argentina for £7.50 is comparable or not. But if you're talking about a very expensive bottle of champagne, and you say, do you see that in the same category? Then if you had your heart set on a top bottle of Bordeaux, then you wouldn't accept a bottle of Malbec from Argentina in substitute for it. If it was your birthday and you were wanting to drink one of the finest bottles from an estate. I mean, you can think of all sorts of examples. A holiday, would you treat a holiday in a resort in Italy might be similar to a holiday in Greece, but if you said, is a trip to New York interchangeable with 3 days camping in the rain in Cornwall, then you might say, no, it isn't. So the consumer, by deciding whether they're prepared to pay a similar amount or more, or on the other hand, more, is the judge of whether the two supplies are similar and therefore interchangeable.
Would you also accept that there is a difference of kind, of pretty fundamental nature, between the supply condition on the one hand and a supplier condition on the other? Because a supply condition is, as you have just been submitting, closely focused on what the actual individual customer is supplied with.
Yes.
To state the obvious. On the other hand, the supplier condition may depend on matters to do with regulation and so forth. It's a far more open-textured type of condition which qualifies the nature of the supply in some but not all the cases, in ways which one would a priori expect the relevant jurisprudence to allow a lot of leeway to the member state.
Well, we're going to get onto this in a moment, but that's precisely my point, which is that in most cases the consumer isn't particularly interested in, it doesn't really affect whether they want the campsite or the trip to New York, depending on the regulation. They don't really care whether the campsite is regulated by Cornwall County Council or not, and they would either don't know or it wouldn't make any difference to them. But as far as Cornwall County Council is concerned, they are very interested, or whoever the regulator of campsites is, and similarly with people providing package holidays. So in most cases, and this is rank at paragraph 50, as far as the supply is concerned, the consumer is not, when you're assessing comparability of the supply from the consumer's perspective, the regulatory position of the supply isn't of particular interest to the consumer. But we say when you're assessing the supplier condition, it doesn't make sense to look at that from the consumer's perspective, because in most cases the differences in the national regulatory regime are of great importance to the state and the regulators, and therefore it doesn't make sense to look at that condition from the consumer's perspective. And we'll see the difficulties with adopting such an approach when one looks at how the courts applied in the BG&H, points BG&H case law, the various factors which the member states can take into account. And when one asks oneself rhetorically, how would you take into account the consumer's perspective? when looking at the guidance of the court on those cases, the answer is it would be very difficult. I think this was a point which my Lord Justice Lewison made yesterday a number of times, but we respectfully make a similar point today. We'll get to that in a moment. But just to finish off on rank, so at 46 to 47, just to finish off there, the court there says that when you're, in that case, which was assessing the supply, or what's being supplied, the supply condition, at 46 and 47, it didn't make a difference either as to the identity of the operators, because there was no supplier condition there. There was nothing to say betting and gambling supplied by casinos or amusement arcades. It was simply, the exemption is simply for betting and gaming. And therefore, 46 and 47, the court says, when you're assessing similarity of the supplies, where there's no supplier condition, differences between where the slot machines are located and who is providing them aren't relevant. And then at 50, and we're again talking about supply condition, the court says that in certain exceptional cases, the court has accepted that having regard to the specific characteristics of the sectors in question, difference in the regulatory framework or the legal regime governing the supplies of goods, and we underline the word supplies, or services at issue, such as whether or not a drug is reimbursable or whether or not the supplier of a service is subject to an obligation to provide a universal service, may create a distinction in the eyes of the consumer in terms of the satisfaction of his own needs. The point being made there is not the regulation of the supplier, but that in exceptional cases, it is possible that the regulatory regime as to the supplies could affect the consumer choice. Now, that didn't happen here, where there were various distinctions in national law between these various different types of slot machine and mechanised cash bingo. But one could think of supplies where the consumer might be affected by the regulation of the, in rare cases, by the regulation of the goods or services, such that a regulated service is seen as being in a different category to an unregulated service. I'm just trying to think of an example, but perhaps giving my holiday example, if a holiday is protected, if the service is protected, perhaps if they're I'm just trying to think of an example where there is one service which is subject to a higher level of regulation.
Well, you might go for an ab to back holiday rather than an
That's
Airbnb.
what I'm trying to think, exactly, that you know that you might be prepared to pay more money for that because you think to yourself, that your money is not at risk. So that is rank. So our second point is that fiscal neutrality is a principle of interpretation. The point to note here the point to note here is we point out the principle of fiscal neutrality is a principle of interpretation and not an absolute principle. And the case on that is Deutsche Bank. We will also see that from the Zimmerman case, which we'll come back to. At Deutsche Bank's at 33. That was a case involving the management of investments. There were two issues in that case. One was, so Deutsche Bank was dealing with high net worth individuals, and they were charging, I think it was 1.5% of the value of the fund, so quite a high percentage. The question was their management of investments exempt? And there were two possible candidates. One was a point we touched on yesterday, which was 1351G, the management of special investment funds, and the other possible candidate was 1351F, which was exemption for transactions in shares. And we'll see that at, if one turns to 665, where the judgment starts, one sees that at little 1, and then the provisions are set out at 4. So what the court decided in that case was that this wasn't the management of special investment funds under point G on the facts, because this wasn't a this wasn't a pooled fund. What Deutsche Bank was doing was dealing with individual clients, and not, it wasn't a pooled fund where, such as a unit trust or an investment trust company. It was where the investors pool their money, and then a company such as Deutsche Bank manages the pool with a shared portfolio of investments. So one will see at 35, it was decided that the activity carried out by Deutsche Bank does not correspond to the concept of management of special investment funds. They then went on to little f, point F at 36. This is 1351F. And what the court decided was that what Deutsche Bank didn't qualify for exemption under point F either. The reason for that was that if one looks at 40 to 43, the service had to be taken into account for VAT purposes as a whole. And what Deutsche Bank was doing was both buying and selling shares, which is what 1351F deals with, but also it was doing other things, including analysis and monitoring, which one will see at 40. So what it was doing wasn't confined to simply purchasing and selling securities under 1351F. And so the conclusion at 43 is, since that service may be taken into account for VAT purposes only as a whole, it cannot be covered by Article 1351F. And then this is the key point. At 45, the court says, considering fiscal neutrality, it must be stated that that conclusion is not called into question by the principle of fiscal neutrality, as the Advocate General, who was Advocate General Sharpston, stated at point 60 of her opinion, which is on page 663. I don't need to go to that because it says exactly the same as what the court says. That principle cannot extend the scope of an exemption in the absence of clear wording to that effect. That principle, that's fiscal neutrality, is not a rule of primary law which can condition the validity of an exemption, but a principle of interpretation to be applied concurrently with the principle of strict interpretation of exemptions. So one has to, it's an interpretive principle, but rather than a strict rule. Before we get on to the further outworkings of that, I would just point out that in Zimmerman, that is repeated at paragraph 50, and that's at tab 34, page 700. There is also a further Advocate General's opinion which does touch on this as well, and that's in the Schloss-Igling case, which is at tab 41, which starts at 796. The court itself in that case doesn't say anything relevant. Schloss-Igling was a case about 132.m, the sports exemption, and it was all about a golf club. The issue is whether certain services provided by a golf club, such as the rental of golf balls and hire of caddies, is exempt under the sporting exemption. But we don't need to go into the detail of that. What's relevant is that in the Advocate General's opinion, Advocate General Hogan, he says at 807, pages 807 to 808, he deals at 55 to 60 with fiscal neutrality. And he refers to the principle at 55, but what he then says at 57 is that in applying fiscal neutrality, the comparable nature of several situations which is required in order for a difference of treatment to fall within the scope of the principle of equal treatment must be assessed in the light of the subject matter and purpose of the provisions in question, as well as the principles and objectives of the field to which the act in question relates. So he says that you have to apply fiscal neutrality in the context of, in this case, the exemption in 1321M. And he goes on in a bit more detail in 23 to explain in that footnote why he says that. And he mentions rank, one will see in that footnote. He says it's not sufficient in that footnote that the goods or services at issue are in competition with each other. They must be similar in the light of the subject matter of the provisions in question and of the aim pursued by them, and the purpose of the principles and objectives of the field in question must be taken into account. And then he concludes that the principle of equal treatment is the same as conducting a consistency test.
Is that reflected in the judgment?
No, because the court didn't go on to consider.
So what do you say the status of that?
It's a persuasive authority in interpreting, in the light of what the court has said in Deutsche Bank, which is that, and in Zimmermann, that fiscal neutrality is a principle of interpretation, and rather than a hard-edged rule of law, that as a principle of interpretation, it has to be applied in the context of all the other rules of interpretation, and which includes strict construction of exemptions, and also sensitive to the context in which it's being applied. And he goes on at 58 and 59 to say that it doesn't require identical treatment, or so as to remove discretion from the which has been allowed by the community to be removed from the member states, which is applicable here because the court has repeatedly said that the member states have a discretion as far as the supply condition is concerned.
But subject to the principle of fiscal neutrality.
Yes, but fiscal neutrality has a specific role as a principle of interpretation. That's what's being said, which as a principle of interpretation, it's not intended to remove. It's not intended that the community legislator, by setting out in Article 132 certain exemptions which allow member states to nominate other organisations in addition to bodies governed by public law. Given that the community legislator has specifically given a discretion, that discretion is not to be removed or very significantly reduced by the principle of fiscal neutrality. Fiscal neutrality is, as he says, a consistency test, i.e. if you decide to exercise your discretion to exempt universities, one can't do it in an inconsistent way by, for example, saying only universities which are, for example, have a royal charter, but not other universities such as LSE, which doesn't have a royal charter, but is in fact, I think LSE is in fact a limited company. And there are other universities such as the University of Buckingham, which does have a royal charter, but is not covered by the HEFKE funding regime. So you can't, the point is that the member states have a discretion, but they can't, once they decide on a category, they can't pick and choose within it in an inconsistent way.
It goes further than that, doesn't it? The principle, according to the cases we've been shown, that if there are other bodies which are materially the same, in other words, there's no material difference between them and, say, a university, then they can't be excluded just because they don't happen to fall within the definition of the university.
And that's the colleges of a university, but
Not
that
just that, but just take the university.
yes.
If a body has all of the same characteristics as the university but happens for some reason not to fall within that definition, so there are no material differences, would you accept that to exclude them would be outside the scope of the national authority's discretion? Or do you say it's simply a question of treating all universities, i.e. bodies which do fall within the definition, in the same way?
Yeah, well, if all UK universities, one can't distinguish between UK universities on how they're constituted or whether or not they are restricted. They're a public sector university which, although it's an autonomous body and not a body governed by public law, is subject to the HEFKE funding regime, as compared to, there are a small number of universities, which I think the University of Law and Buckingham are the exemplars, who aren't covered by the HEFKE system, and therefore they're not restricted to the £9,000 odd in terms of charging.
I think the FTT refers to BPP as being a profit earning university.
So within the category of universities, one can't simply, it's clear that as far as universities are concerned, the UK hasn't, and I think this is the point that my learned friend made about SAE yesterday, the UK hasn't relied on the optional conditions in 133 to remove the exemption from profit-making bodies. And because we haven't done that, the UK can't distinguish between non-profit-making universities and the small number which are profit-making. But my learned friend, when she began yesterday, pointed out a number of different respects in which she said that the appellants as APs were similar to universities in that they provided, at least some of their courses were courses very similar or the same as courses offered by the exempt universities. but the FTT decided that there were major differences between the APs and the exempt universities, and also between the APs which hadn't established that they were colleges of university and any body which was a college of university, either because it was a university college or because it had satisfied the SAE test. So the appellants can't say, we say that if there was an arbitrary distinction based, for example, on profit-making nature, that is where the principle of fiscal neutrality would apply. But these distinctions aren't arbitrary. The distinctions are based on the national regulatory regime, and the Kugler-Dornier-Kingscrest line of authorities, as far as points B, G, and H, specifically allow member states to take into account the national regulatory regime where there are significant differences, and we say that must apply equally to I. We'll get onto that in a moment, but we say the same analysis must apply. So actually, this, having looked at Advocate General Hogan, I hope I can just indulge the court's attention for 1 second, just to go back to something I said I wasn't going to go to, which is that if one looks at what Advocate General Hogan says, that one has to be careful in applying fiscal neutrality, that one doesn't effectively erase distinctions which have been permitted by community law, i.e. the discretion given to member states to treat, for example, in these cases, to treat certain suppliers in a different way here of education to suppliers which haven't been so recognised. Going back to Deutsche Bank, the explanation by Advocate General Sharpston is actually perhaps worth reading, because she says something very similar. That's 60, which is at page 663. She says, while the principle of fiscal neutrality in VAT may explain the relationship between explicit exemptions for both direct investment and the management of joint investment funds, and she's dealing here with Article 135, I do not accept that it can extend the scope of an express exemption in the absence of clear wording to that effect. And then she says, as the German government observed at the hearing, it is not a fundamental principle or a rule of primary law which can condition the validity of an exemption, but a principle of interpretation to be applied concurrently with and as a limitation on the principle of strict interpretation of exemptions. And this is the point which Judge Advocate General Hogan also makes. It is clear from the case law that activities which are to some extent comparable, and thus to some extent in competition, may be treated differently for VAT purposes when the difference in treatment is explicitly provided for. Moreover, if all activities partly in competition with each other had to receive the same VAT treatment, the final result would be, since practically every activity overlaps to some extent with another, to eliminate all differences in VAT treatment entirely. That would presumably lead to the elimination of all exemptions, since the VAT system exists only to tax transactions. So one has to be careful, because the exemptions that specifically in B, G, H, and I, and N, specifically allow for the same supplies to be treated differently depending on who's supplying them, but one doesn't apply fiscal neutrality in a way which erases the distinction which the community legislator specifically provided for. And this is where I'm about to now turn to, because the court has effectively dealt with this in the Bridport and MDDP cases.
And that paragraph of the Advocate General's opinion was expressly approved at
Yes.
43,
Yes.
45 rather, of
Yes.
judgment. Right, where are we going next?
Can we go please to Bridport, which was a case about a golf course in Dorset.
Where's that?
It's at tab 37. It's, I was actually involved in that case. It's supposedly, I know nothing about golf, but it's supposed to be a remarkable golf course because the last hole is halfway down a cliff, and the evidence in it was that people came from far and wide to play Bridport to say that they played the final hole because it was so different to it. But in Bridport, the club itself was a private members golf club, so it wasn't a profit-making club, and we'll see that from tab 10. It charged annual membership fees to members, so it had about 700 members who paid for the year to have access to the course. That's at paragraph 11. It was also charging what are called green fees, which are for people who are either a member of a different course or not a member of any course to come and play and just pay 30 or 40 pounds for a round of golf rather than being an annual member. Bridport, what one will see from 13 is that Bridport originally charged, it treated its annual membership fees as exempt but charged VAT on the green fees, the day paid by day fees, and then it sought to argue, it sought to recover the VAT by saying that it shouldn't have paid VAT on the green fees either. The UK authorities, HMRC, refused the reclaim and said, no, you're right, the green fees should have been standard rated. And the reason that the HMRC argued that was because HMRC was arguing that effectively if Bridport as a non-profit making club could exempt the green fees, there'd be a distortion of competition with profit making clubs, i.e. the person on a Saturday morning, the consumer on a Saturday morning who has to decide, do they want to go to Bridport and play this wonderful hole that's halfway down the cliff, or do they want to drive somewhere else to a commercial golf club? If the commercial golf club is charging VAT on the £35 for a round of golf for somebody who's just going for the day, then they might be put off by that and choose Bridport simply because it's not charging VAT. So the UK was arguing in that case that in Luxembourg that that Bridport was only entitled to exempt the annual membership fees. So what was not in dispute before the National Court, which was in that case the Upper Tribunal, was that Bridport met the supply condition. So what it was providing was the right to use the golf course, and that was closely linked to sport, to the green fee customers, and we'll see that at paragraph 15. And it was also not in dispute that it was a non-profit making organisation referred to in 132 in point N, and therefore that it in principle met the supply condition as a non-profit making organisation. And the court in Luxembourg agreed with that characterisation at 21 and 22. Again, at 21 and 22, the court said that the supply of golf met the supply condition, it being immaterial whether it is provided to a member of the body, so an annual member, or to a visiting non-member by way of a green fee. But the relevant question is set out then at 16. You'll see that the dispute was whether it was lawful for the UK to exclude the supply of the green fees from the exemption, either on the basis of one of the optional conditions, Article 133D, which refers to distortion of competition, or 134B, which we don't need to worry about. That's where the supply is not essential to the transactions exempted, and that's 134B is set out in 23, but we don't need to worry about that. The question for our purposes was distortion. The point which the UK specifically made in that case is, we'll see the factual background to it, in fact, at paragraph 11, where it's explained that there were about 700 annual members, and then at the time, Bridport was charging between £32 and £38 to anybody who wasn't an annual member but turned up and wanted to pay a green fee. But then you'll see the prices, this is the important point at the end of that paragraph, the prices of the annual subscriptions and the green fees were set by Bridport, taking into account the prices charged by neighbouring non-profit making clubs and also by one commercial golf course operator. So though Bridport had some unique features, such as the final hole halfway down the cliff, nevertheless Bridport was setting its prices with an eye not just to other members clubs but also a profit-making club. So just as somebody who's selling £7 French wine might take into account how much somebody selling a French bottle of Malbec might look at how much somebody in Sainsbury's is charging for a bottle of Argentinian Malbec, and one might then conclude that because of that pricing, the consumer must see the products as sufficiently similar to be interchangeable in the eyes of the consumer. Bridport was setting its prices by reference to a commercial competitor, a profit-making golf course, and the thought there is that Bridport wouldn't have been doing that if the two different courses and the facilities being offered, the clubhouse and so on, were not comparable in the eyes of the consumer. Because if this was if Bridport was of a significantly different quality to the commercial competitor, Bridport wouldn't have been worried about what the commercial competitor was charging. If it was in the same league as, I don't know, Muirhead or wherever it is in Edinburgh, one of the world's top golf courses.
What are we getting out of this judgment?
What we're getting out of it is that the UK argued that, well, let's jump to what the court decided, which is on questions 6 and 7. It's at paragraph 33. The UK said that, you'll see that the court summarises the question. In essence, does the optional condition in little d, which relates to distortion of competition, must it be interpreted as allowing the member state to exclude from the exemption in point M a supply of services consisting in the grant of the right to use the golf course when that supply is provided to visiting non-members of the body? And the court says no, you cannot, the UK was not entitled to withdraw the exemption because it's, in essence, it's hardwired into the exemption that different suppliers are treated differently. Even if the supplies are comparable, the supplier condition hardwires in a difference in treatment, and the UK was not entitled to use 133D to erase the difference in treatment that point M provides for, which is that bodies such as Bridport, which are non-profit making, are exempt. They're exempt both on their annual membership fees and on the green fees. The profit-making club down the road, even if it's supplying a comparable service, has to be taxable both on the annual membership fees and on the green fees. And the court says that at 36. In this connection, it should be observed that the scope of the exemptions in B, G, H, I, L, M, and N, note the reference to point I, which is our exemption, is defined not only by reference to the substance of the transactions covered, but also by reference to certain criteria that the suppliers must satisfy. In providing for exemptions from VAT defined by reference to such criteria, the common system of VAT implies the existence of divergent conditions of competition for different operators. So the UK wasn't entitled to erase what the community legislator had specifically provided for, which was that two different groups of suppliers had to have different VAT treatment, even if the supply they were making was comparable.
This was about, is this right? This was about Article 133D,
Correct.
which places which actually limits the extent to which, or the kinds of conditions that can be imposed by the national authorities. Is that right? It places a limit on it.
Yes, so if one looks at the optional condition, which is at, I think it's at, I might have seen it yesterday, it's at page 10.
Yeah.
So the member states, in relation to the 7 exemptions they're listed, B, G, H, I, L, M and N, at D, they may subject in each individual case the bodies to one or more of the following conditions. And at D, the exemptions must not be likely to cause distortion of competition to the disadvantage of commercial enterprises subject to VAT. So the UK said we're entitled under 133D to withdraw the exemption from Bridport as a non-profit making body as far as green fees are concerned, because there's a risk of distortion of competition with the people down the road who you set your prices in comparison to, because they'll have to charge VAT when the person on a Saturday morning who isn't a member of a golf club is deciding, should I drive right out of my driveway towards the commercial golf course, or left towards Bridport. I might be influenced by the fact that Bridport isn't charging VAT on the green fees. And therefore, the UK sought to rely on 133D to withdraw the exemption from the non-profit making golf courses to level the playing field. And the court said, no, you can't do that, because what you're doing, if one looks at 132.1m, is that the exemption itself specifies a distinction. The exemption is not for the supply of all services closely linked to sport, but only for services closely linked to sport by non-profit making organisations. And what you, the UK, are trying to do is actually to erase the distinction which the community legislator has specifically provided for.
Yeah.
So, what we take from this is that if you apply the consumer perspective to the assessment of the exemptions which the court refers to in Bridport, the 7 exemptions in total, the consumer, focusing on whether the supply is interchangeable from their perspective, may regard the supplies as identical or similar. So here, because Bridport was setting its fees by reference to the commercial competitor, one takes from that that it must have only been doing that because it saw itself as in competition and its supplies as being similar to those of the commercial golf club. But that doesn't mean that the suppliers are comparable. The supplies may be comparable, but it doesn't mean that the suppliers are comparable for the purposes of the exemption. And this is where it becomes odd to apply the consumer perspective, just drawing on the point made by your Lordship, Lord Justice Lewison yesterday. The consumer may not care less as to the status of the supplier in certain circumstances, but that is not relevant where you're looking at the supplier condition. So just to give you an explanation of that, in this case, those people who wanted to be annual members might have cared whether the club was non-profit making or not. They might have loved golf so much that they wanted to be on the committee of the Bridport and West Dorset Club, and obviously they can only be on the committee if it's a non-members club. If it's a profit-making club, they're unlikely to be able to join the board of directors of the club. So those who are annual members may have cared what type of supplier they were dealing with, but those who are just turning up for the day for a green fee, why do they care whether it's a members club or not? They're just turning up for the day, and it's of no interest to them, one would assume, as to whether this is a profit-making club or not. They want to play a particular quality of golf course for a particular price, and it doesn't matter whether it's a members club or not. But the court is stressing in 36 that the exemption, even if the consumer sees the supplies as being in competition with each other, that doesn't allow you to erase the differences specifically provided in those exemptions between bodies which comply with the supply condition and those which don't. So we say that fiscal neutrality doesn't require equal treatment of all supplies which are substitutable from the consumer's perspective where there is a supply condition.
This case doesn't actually discuss fiscal neutrality, does it? What it seems to be saying is that the difference in treatment is built into the legislation, to the primary Euro legislation, because it's there in little m.
Yes.
So it's not dealing with the question of fiscal neutrality as between different bodies which may claim them to be within the relevant exemption.
I mean, it is about withdrawal of the exemption rather than the exemption itself, but what it illustrates is that the differences were intentional between the supply condition does have a specific purpose, and you can't erase that, the distinction between those who qualify and those who don't, based on the member state's recognition, provided that the member state exercises its discretion consistently.
Well, there are 2 points here, aren't there, wrapped up. The one is that the legislation envisages divergent conditions for different operators. And as you say, in many cases, the consumer won't care who the operator is. If I want to park my car, I don't mind whether it's a local authority car park or a private one. So that's one aspect. The other aspect, which I think is where my lord is going, is suppose that 2 different suppliers claim to be entitled to the exemption because they fulfill the supplier condition. Doesn't fiscal neutrality have a part to play in deciding which of the suppliers should be regarded as satisfying the supplier condition?
Yes, in this case, Bridport, there wasn't an issue as to that is fair to say.
Quite. Bridport was a non-profit making body, so insofar as there was a supplier condition within the exemption, plainly it satisfied it.
Yes. So Bridport satisfied the supply condition, the commercial competitor down the road didn't.
Yeah.
The point is, though, that this is where we get onto what's relevant to us, which is, do you then assess fiscal neutrality by reference to what the consumer thinks about the supply condition? But the issue here is that...
No, that's the point that I'm making. Assume you're right, that the supplier condition, satisfaction of the supplier condition, doesn't depend on the consumer's point of view. Nonetheless, fiscal neutrality may have a bearing on who is entitled to claim to satisfy the supplier condition.
yes, we accept that fiscal neutrality does apply to the supplier condition, but we say you don't look at it from as the Upper Tribunal agreed with us, you don't look at it from the consumer's perspective, you just look at the comparability on an objective basis as to the rationality of the way in which the member state has exercised its discretion. So if, for example, all universities are comparable because in one way or another they have to obtain state approval to call themselves a university, it's not relevant. If all of them have to gain university title and degree awarding powers, it's not relevant to look at whether they've got a royal charter or not, or in the case of Oxford and Cambridge, that they were set up by an Act of Parliament or in some other form. That would be irrelevant. So we accept that fiscal neutrality applies, but not from a consumer perspective. The other important case on this point is MDDP, which we've already looked at, and that was the Polish case, which my learned friend took you to, which is at tab 35. And really just to deal with that succinctly, the court concluded in that case that a general exemption for all suppliers of education services was incompatible with 132.I. That case is at 35, tab 35, and it starts at 719. And the relevant passages are at 36 to 39. So the court is again stressing that the member state has to identify which organisations it has to exempt only those services, educational services, in the list in point I, where the supplier is either governed by public law or it has to exercise its discretion insofar as there are other organisations recognised by the member state concerned as having similar objects, and therefore Poland wasn't entitled to grant the supply of the educational services to all private organisations by including also those whose objects are not similar to those of bodies governed by public law. I'm just reading from 35. And the court says the same again at 39, that you're not entitled to what it calls a general exemption. What is also worth noting in that case is the court then went on. So in that case, MDDP was arguing, it was actually trying to argue that it wasn't exempt. It wanted to be taxable because it wanted to recover input tax. So the court then said that in order to, it went on to look at direct effect to disapply the exemption and what MDDP would have to establish to show that it was undoubtedly outside of the scope of the member state's discretion to recognise a body as having similar objects. And the court there went on to say at 54, it's for the national court to determine whether the exemption of services supplied by an organisation such as MDDP, in accordance with point I, exceeds the discretion granted to the Polish legislature. It is for that court to examine the object and conditions of MDDP's activity by comparing them with those of Polish bodies governed by public law providing educational services. What the court is saying there is that you compare by reference to the object and conditions of the activity. There's no reference to assessment of the supplier condition by reference to the point of view of the typical consumer. or to sort of paraphrase that, the court doesn't say, look at the object and conditions of those activities, but if the typical consumer wouldn't take those factors into account, then the member state can't, the member state's discretion doesn't extend to exempting that supplier. We say that, in fact, what would happen if one adopted the appellant's analysis, which is that the member states are entitled to recognise bodies by reference to the Kugler list of criteria, but then there's a second question, which is whether applying fiscal neutrality from the consumer perspective, whether the consumer would find any of those criteria to be relevant, that would restrict the member state's discretion in applying recognition, because the member state could all very well take into account the object and conditions of a body's activity in deciding to extend the exemption beyond bodies governed by public law. But if the typical consumer wouldn't be interested in those particular factors, in principle allowed under the Kugler analysis, then if that factor is insignificant to the typical consumer when making their choice of which supply and which supplier to buy their services from, then the member state, even with on one hand, the community will be allowing, by reference to the Kugler list of factors, a member state to take into account, for example, the national regulatory regime. But on the other hand, if the consumer isn't interested in the national regulatory regime and doesn't make their choice of supplier based on taking that into account, then one takes away with the other hand the discretion which the member state has been allowed under the Kugler list of factors. And so effectively what you're then doing, if one applies the test of fiscal neutrality from the consumer perspective, one's actually, on the one hand, saying you can distinguish based on the regulatory regime, but on the other hand, severely limiting what regulatory, in the circumstances in which you can exercise your discretion to identify other similar bodies as well as bodies governed by public law, because it's only factors identified in the Kugler line of authorities which the typical consumer would be interested in, which you can rely on when exercising your discretion. That would be, we say, that would be a very important restriction on the member state's discretion, and we say rhetorically, why wouldn't the Court of Justice have mentioned that? We say in relation to all of the BG and H cases that the court nowhere mentions when identifying the Kugler list of factors that reliance on those factors is subject to the consumer perspective. But given that this would be, if one applied the appellant's analysis, this would be an important restriction on the member state's discretion, why wouldn't the court have mentioned that at any stage in any of the B, G and H line of cases? And just to illustrate that, the court does give very specific guidance where the consumer perspective is in play. The court does give detailed guidance on how to assess fiscal neutrality from the consumer perspective. The case on that is K-OI. I'm probably not doing justice to finish. And that's at tab 38. I think it was touched on very briefly by my learned friend yesterday. It was a case about the well-worn distinction between paper books and digital books. In this case, not any sort of digital book, but a digital book on some of the physical support, such as CDs or memory sticks, rather than purely digital books. So the issue in that case was a reduced rate of VAT in Finland on the supply of books published in paper format, and whether it could be applied to the supply of books published on other physical supports rather than paper, such as CDs, CD-ROMs and USB keys. The Finnish authorities refused to apply the reduced rate to books which were on physical supports other than paper. We'll see that at paragraph 14, which is on page 765. The body beginning with a K is the Finnish Tax Authority. I won't attempt to pronounce that. The taxpayer argued that that was contrary to fiscal neutrality, and that's at 17. This was a question of the supply condition rather than a supply condition, and therefore, because it was a case about the supply, the court set out the principle of fiscal neutrality by reference to rank, and that's at 24 and 25. You'll see rank is cited at 25, and then what is noteworthy in that case, at 29 onwards, the court gave very specific guidance on how the average consumer's assessment of the different types of books was to be carried out. I don't need to read it out, but the court looks at, for example, which market are you looking at when one's talking about the consumer perspective. It's the national market, because there might be different member states may have different degrees of penetration of things like CD-ROMs. This is a case dated back a number of years, but from 2014, but the court gives detailed guidance in that case of how to apply the assessment from the perspective of the average consumer. What we take from that is a case about the reduced rate rather than the exemptions, but it's very noteworthy when looking at the case law on the exemptions with supply conditions, particularly in BG and H, that the court doesn't give similar detailed guidance on how to assess similarity from the consumer perspective. And we say that's noteworthy. That suggests that one isn't, when one's looking at the supplier condition, assessing from the consumer perspective. I should probably go through this relatively quickly, but we say that there are quite a number of cases on BG and H. I don't need to, in each case, obviously read out the Kugler rubric. I can make the points I make on each of these cases are A, that in none of them is the consumer perspective referred to when the Kugler Dornier King's Crest rubric is referred to. Secondly, the court interchangeably refers to the case law between BG and H, and the court will see that the court in Luxembourg relies on, it goes from looking at in Kugler at points C and G, specifically in our case G, which has got the particular type of wording, bodies governed by public law, and then other similar bodies. Then it goes on to Dornier point B, and then it goes on to King's Crest, which concerned points G and H, and then in a whole sequence of cases it goes back over B, G and H, but the whole case law is referred to interchangeably as you go through the whole series. But the most important point we derive from all of these cases is that the court allows the member state to take account of the framework of national law in its rubric in Kugler, but then when exercising its discretion as far as the supplier condition is concerned, then it's difficult in each of these cases when one looks at the actual application or the more specific guidance given by the court to the facts of those cases, how one would apply the typical consumer's perspective. So to take Kugler as an example, which is at tab 23, the rubric which is used in all these cases subsequent to Kugler is set out at 57, 58. I think we've seen that. So at 57, the court says that the member state, in exercising its discretion under here particularly G, can take into account the practice followed by the competent administrative body in analogous situations. That's at 57, and then at 58. The National Court will thus be able to take into account, and we've seen the whole list, national, regional, legislative or administrative or tax or social security provisions, and then the fact that associations carrying on the same activities as the claimant are already entitled to similar exemption, and then given the public interest inherent in those activities. Just stopping there for a second, there is a slight difference as one goes through the list of authorities where the public interest becomes a separate head, as it were, of consideration, whereas in the original case, the first case, Kugler, the public interest seems to be tacked on to the question whether the same activities have already been are already entitled to a similar exemption. But one will see as you go on to, for example, King's Crest, that those two different points are separated out, and then the fact that the costs of the services may be largely met by statutory health funds or by social security bodies with which private operators, such as a claimant in the main proceedings, have contractual relations. I mean, the points we make there are that the as far as the supplier condition there is concerned, there's no. It allows the member state to take into account the framework of national law under which services are provided in order to decide whether the supplier of the services should be recognised, and that's effectively what we've done in the UK's done in I. There is no suggestion, we say at 56 to 58, that layered on top of that is then a further condition that the member state can look at these various features in 58, but that is subject to whether they will be, any of these features will be relevant to the typical consumer.
How does that fit with what the court said in Kingcrest?
Yes.
Because the court in Kingcrest, I'm looking at tab 27, page 537, repeats the Kugler formula, paragraph 53.
Yes.
But then it says, must be recalled the principle of fiscal neutrality precludes treating similar supplies differently. Your argument divides up supply on the one hand and supplier on the other, and you accept that whether a supply is similar is to be judged from the perspective of the consumer, but you say that whether the supplier is entitled to the exemption is governed by different criteria, many of which the consumer won't care about. But
Yes.
it's puzzling then, if that's right, that the court says what it does in paragraph 54 of King's Crest.
But then at 55 to 58, the court then says, with respect, it goes on to give a bit more detail.
Right.
Then at 55 it says, in the main proceedings, it's for the National Court to determine, having regard to all those matters, whether the recognition of King's Crest as a charitable organisation, so as a supplier for the purposes of the exemptions in G and H, which are both ones with the same rubric as, the same type of wording as ours, bodies governed by public law and other organisations recognised by the member state, entails infringement of the principle of equal treatment in relation to other operators making the same supplies in comparable situations. So we say that that's what the member state has. And then going down below that at 57, for the purposes of determining whether the limits of the discretion have been exceeded in this case, the National Court may, on the other hand, take into account in particular the fact that under the amended VAT Act, entitlement to the exemptions provided for in G and H extends to all organisations registered under the Care Standards Act 2000, as well as the fact that the Act and the amended VAT Act contain specific provisions which not only reserve entitlement to those exemptions, but also govern the conditions for providing those supplies by making the organisation which provides them subject to restrictions and checks by the national authorities in terms of registration, inspection and rules concerning both buildings and equipment and the qualifications of the persons authorised to manage them. Just to put it in a nutshell, my learned friend says what we're talking about is an exemption for supplies, she says, supplies of education, but she says that the supply condition isn't freestanding. She says it's just another feature of the exemption, and therefore you apply the test of fiscal neutrality to both elements because it's just a single exemption for in a comprehensive single sense of education provided by these particular types of supplier. We, however, say that the court has, well, in fact, the legislator has, and built on that, the court, in its analysis, has provided different conditions, both for the supply and the supplier, because the Kugler list of features which the member state can take into account only applies to the supplier. It doesn't apply to the supply. So it's actually, the member state has no discretion, as I think Mr. Blades was saying yesterday, to decide whether or not to exempt university education. The supplies are either within point I or not. The court has decided that most types of education are covered by I, but there are a limited number of types of education which aren't, such as one will see from the Dubrovin case, swimming tuition. That is not covered by I. Although the man in the Clapham Omnibus might think that swimming education or swimming training is a type of education. That isn't the sort of education that is covered by I. Driving tuition is also not covered, and sailing lessons are also not covered. But if you fall within, the member state has no discretion as far as the supply condition. The education is either of the types specified in I, so school and university education and vocational training, or it isn't. The member state can't decide, well, teaching Italian is not that's just an arbitrary thought, or teaching physics isn't a particular benefit to the UK, and therefore we won't exempt the teaching of Italian or philosophy or something like that, the teaching of Italian or philosophy is either exempt or it isn't. The discretion applies to the supplier element, and the court has set out specifically in relation to the supplier element the features which the member states can take into account in the Kugler list. So therefore,
The King's Crest case, in the passage that my lord just took you to, in 53 it talks about what you call the Kugler rubric.
yeah,
And then it goes on in 54, it says, in addition, then it talks about fiscal neutrality. And Kugler itself doesn't seem to have been, that seems to be about whether it is to do with the exercise of discretion, but it's whether which organisation should be recognised as charitable as it then was for the purposes of G. So when the member state decides on that, it can take into account all of these things in deciding whether something's charitable or not. But then there seems to be, according to King's Crest, then an overlay, if you like, of the rules of fiscal neutrality. So having the member state having made that decision as to which entities to treat as charitable, there's then it seems from 54, there's as it were a separate overlay on that, which is that you then look to ensure that similar supplies in competition with one another are not being treated differently.
yeah. But we say that you take that, that's an introductory, as the court sometimes does, it sets out a, when it's explaining its ruling, it sets out perhaps a general statement and then goes and gives more detail, and that's precisely what's happened there. It's changing, it's set out at 53, the Kugler and Dornier rubric, as I call it, and then it's changing topic to get onto fiscal neutrality, but it then gives detailed guidance at 55 to 58, and it's effectively making the same point as we make, which is that fiscal neutrality does apply to the supplier condition. We accept that, but it's looking at whether the other operators are comparable or not from the consumer perspective, but simply whether the criteria are being applied consistently, and that's at 57 when one sees the reference to the fact that all of the relevant organisations were registered under the Care Standards Act, and also that the relevant provisions govern the conditions for providing those supplies by making all of the relevant organisations subject to restrictions and checks by the national authorities.
So that's all about comparable situations,
Yes.
you say?
Yes. So we say that's consistent with our point. We accept fiscal neutrality applies, but you're just looking at comparability as the Upper Tribunal accepted, and not at the consumer perspective. So the point that the court's making is if a body which was subject to the Care Standards Act and which was subject to the relevant restrictions and checks by the national authorities, if one of those was singled out for some reason and wasn't granted the exemption, that is where fiscal neutrality would step in, where you have otherwise comparable suppliers, but for some irrational reason, a supplier or suppliers are arbitrarily not covered. And the point we make...
Can I just ask you one other question?
So,
In assessing comparability, who does that? Is it the administration of the member state, the legislature, the courts?
Yes, so the Kugler, I think my learned friend actually covered this yesterday. I think in Kugler itself, the reference initially is to the National Court, but as she pointed out, as the rubric is repeated over and over again, the court actually points out that in the first instance it's for the national authorities when they're exercising their discretion. So what the court is saying in the Kugler rubric is these are the permissible factors you are entitled to take into account. So you're not necessarily required to exercise your discretion on a tick box basis, taking all of them into account, but these are permissible factors you may take into account, such as the funding, the national regulatory position, and so on and so forth, as permissible points of distinction. But if you exercise your discretion based on the regulatory framework, then as a national authority, all comparable suppliers within that same framework must then also be exempt.
So in translation to this case, Parliament has exercised a discretion. Parliament has decided that APs are not in a comparable situation to the others in the note.
Yes.
And the only question then for the courts is does that go beyond the permissible limits of the discretion?
Correct. So what we say is that the UK was entitled to take into account the national regulatory framework when deciding who to extend. Well, my learned friend explained correctly that in fact there aren't any universities which are bodies governed by public law in the UK, because unlike in other member states where universities might be state bodies, the UK universities are deliberately set up as autonomous bodies, and therefore there is no university in the UK is actually a body governed by public law. And that's decided by the University of Cambridge case. But the UK was entitled in deciding which other bodies to recognise under point I to take into account the regulatory framework, and therefore to specify universities which have the particular features we've discussed, which is university title and DAPs, which puts them on a different regulatory basis. And then also to extend the exemption to, as Lady Justice, as she then was, Arden in FBT, to bodies which were so integrated with and imbued with the objects of a parent university that they shared the objects of the parent university.
And what about further education colleges?
Well, again, they are subject to their own specific regulatory regime. The question there is, what one can't do is arbitrarily exclude. One can't say we're taking into account the regulatory regime for each of these categories, but then within that grouping, then pick out individual bodies and then say, even though they otherwise fall within the national regulatory framework for that category, then say that, but we're not going to grant it to this university or that FEC. The point which we made, and I perhaps don't need to labour it in respect of every single case, I can perhaps counter through the authorities after Kugler, King's Cross and Dornier, but the point we make, and it's I think the point which the court has already apprised of, which is that some of the factors which the CJU expressly stated that the member states could take into account are ones. I think there are three different sub-points here. Either a typical consumer won't be aware of, or even if they knew about them as a second category, they might be unable to assess, or ones which the typical consumer might know or could find out about if they had sufficient interest, but they might have no relevance to the consumer's choice. So as far as factors that the typical consumer would be unlikely to be aware of, the practice followed by the competent administrative body in analogous situations, that's in Kugler, which we just saw, the first point in Kugler at 57. Well, the typical consumer, even if they were interested, would probably almost certainly be unable to find out what the practice followed by the competent administrative body in analogous situations was. And they might also be unable to find out to what extent the cost of the services was largely met by the state. It might not be public knowledge whether the state was funding. We've seen it in some of the German cases. There was a limit, I think, of 40% in some of the cases and 2/3 in others, as to different exemptions. But how does the consumer know how, when they're dealing with a body supplying forms of medical care, whether the other customers are being funded? They'll know whether they themselves are being funded by social security bodies, but they won't know whether the other customers for different types of medical care offered by that supplier are funded by state social security bodies or not. So they'll have no, they simply won't be able to know whether the services are largely funded, of that supplier are largely funded by the state. And then as to other of the Kugler criteria, even if a typical consumer knew about, was aware of, in principle, the public interest of the activities in question, the typical consumer is unable to, is not in a position to assess the public interest of the activities of the taxable person in question. Is really a question for the state and the regulators. And the third point is that even where the typical consumer might know or could find out about certain factors, if they had sufficient interest to do so, for example, the national, regional, legislative or administrative or tax or social security provisions, so the national legal framework, as lawyers we might be untypical consumers in being interested in that sort of thing, and we could find that out. But even for us, interested as we are in the national and regional legislative or administrative framework, that might have no relevance to us when we're making our choices as a consumer. So then the question is, why is that specified as a factor that the member state can take into account when it's unlikely to be a factor that a typical consumer, even if they were bothered to, even if they were untypical and were concerned enough to look all of those matters up, why is that? Why do you then apply the consumer perspective? And what the consumer is interested in is whether the supplies, in most cases, whether the supplies are interchangeable, and not on finding out about the national or regional legislative or administrative framework. We say it doesn't make sense for the CDAEU and Kugler to identify a list of factors which the member state can take into account in exercising the discretion, but then impose a further restriction on the discretion of the member states, so that the member state can only rely on any of those factors if they are significant from the consumer perspective. And one will see that in the list of B, G and H cases. All of them cite the Kugler Dornier King's Crest rubric. None of them then go on to refer to the consumer in the BG and H points BG and H line of authorities, refers to any assessment from the consumer perspective. And then when one attempts to, when the court goes on to the specific guidance as to how to deal with the specific application of fiscal neutrality to the relevant circumstances in each of those cases, it's difficult to see that the exercise of the discretion and then fiscal neutrality in each of those cases, it's difficult to see how the consumer perspective is relevant or could be applied. So I don't want to take up a lot of the court's time with this, but the cases that we say are relevant here, perhaps I can just give references and touch on perhaps one or two more without then taking up too much of the court's time.
How are we doing for time? You're still on ground one, I think.
Yes. Well, perhaps I can just, in that way, canter through the cases and give the court, rather than repeating the same point endlessly, but just so that you know what my point is, and then if you wish to turn up some of the points, I can then deal with all of these cases in sort of 5 or 10 minutes rather than and then move on
Are
to
they
the next one.
listed in your skeleton argument in any convenient single location?
Well, we refer to them at paragraph 10,
I know you refer in general to the line of authority,
but the point I can give you perhaps references now to each of them, and then perhaps just touch on perhaps one more. So that the cases we rely on, further cases we rely on are LUP, which is at tab 29, and we saw that it was a case yesterday about medical tests and the 40% point. So in each of these cases, there's a reference to the Kugler, Dornier, King's Crest line of authorities, in that case at 53. But we say, because that was a case about the 40% percentage requirement in Germany, the Court of Justice didn't question whether a typical consumer would have been able to know what the percentage of the tests in the laboratory were covered by Social Security insurance. They wouldn't know. They'd know whether their tests were being paid for by the Social Security. They wouldn't be able to tell for the hundreds of other consumers whether, or indeed care about whether other people were being paid for such that they satisfy the 40% limit. So that is LUP at 53 and 54. Then there's Zimmerman, which concerns point G. LUP was about point B, like Dornier. Zimmerman was about point G. That's at tab 34. One sees the guidance on King's Crest, Dornier, and LUP at 31. And again, one sees in that case that, although that case was about point G, there's a reference to Dornier and LUP, which related to point B. So again, there's this transposition by analogy of the reasoning. That was a case about the 2/3 threshold in German law as regards, in that case, it was an outpatient care service. And that's, you'll see that at 35 to 37. And the court held that the German requirement that 2/3 of the costs be borne by the statutory social security or social welfare services didn't go beyond Germany's discretion. That's at 37. No mention again of the consumer perspective. And again, there's the question, how would a typical consumer know what percentage of the suppliers, Ms. Zimmerman's outpatient services, were borne wholly or partly by the statutory social security or social welfare authorities? Then there's Go Fair, which is at tab 39. That was a case about an employment agency placing nurses to care establishments. And this one is worth focusing on just for a short few moments. That's at tab 39, and it was a case about G. The point here is it's very difficult to understand how you'd apply the consumer perspective to the analysis in Go Fair, because in Go Fair the relevant supplies were the placement of nurses and geriatric nursing assistants with the care establishments, whereas there are two different things happening here. One, there's an employment agency supplying nurses to the care establishments, and the second supply is the care establishment supplying care to the individual people being cared for. And one will see that at paragraphs 10 to 11 on page 771. The Kugler-Dornier-King's Crest guidance on recognition is at paragraph 20 on 773. And you'll see that's in the middle of the page on 773. And then at 26 and 28, when applying that guidance on the final page, the referring court seeks to ascertain whether a company such as Go Fair, the employment agency, may, by virtue of its activity of supplying qualified care staff, rely on G in order to be recognised as a body devoted to social well-being. And the court says at 28, no, because as regards the term devoted to social well-being, it is clear that the supply of workers is not in itself a supply of services of general interest carried out in the social sector. It is irrelevant in that regard that the staff members concerned are care workers, or that they're supplied to recognised care establishments. So the difficulty is, how do you apply fiscal neutrality here from the point of view of the typical consumer, where you've actually got two different consumers you're talking about? We're dealing with nurses who are providing care to vulnerable people or sick people, but the only difference is whether they're directly employed by the care establishment or they're provided by the Go Fair Employment Agency. But the consumer for the Go Fair Employment Agency is actually the care establishment, whereas the consumer for the care establishment services is the individual. Even if one just looks at from the viewpoint of the final consumer of the care services, i.e. the person who's unwell, the court doesn't assess whether the typical consumers of the care services would have known or been interested who employed the people who were ministering to them while they were unwell, whether they were employees of the care establishments or actually agency workers provided by Go Fair. So that case illustrates the difficulties of applying a consumer perspective when deciding whether a member state has exceeded its discretion as far as the supplier condition is concerned. And then just quickly going through the remaining cases, there's Les Jardins de Jouvence at tab 40. That was a case about a serviced residence in the Walloon region of Belgium. The point there is that, and I can just give the court the references, the guidance on recognition in the Kugler line is at 35, but what was significant to the court at 36 was that the Belgian region of Wallonia applied the same legislation to both. There was a single piece of legislation designed to provide a framework both for service residences, which were presumably for less infirm elderly people, and care homes old people's homes, which were presumably for more infirm old people. And the court there pointed out at 36 that the licensing regime, as well as being a single piece of legislation, contains certain common conditions and requirements to service residences and to retirement homes. We say, based on that analysis at 36 of Les Jardins de Jouvence, which, as I say, is at tab 40, not only is there no mention of the consumer perspective, but it's difficult to see, there's no suggestion of the National Court being required to consider whether the typical consumer in Belgium for elderly support and care would either know about or care whether the licensing conditions in Wallonia were shared with the licensing, in some respects, with the licensing conditions for the operators of retirement homes. So that detailed analysis at 36 of Les Jardins de Jouvence, when we say that demonstrates or strongly suggests that one doesn't apply a consumer perspective. And then finally, Finanzamt, in fact there's three more. Finanzamt D, which is at tab 43. Again, Kugler, Dornier and King's Crest, the rubric is given at 44. The point in that case, that was about a registered nurse who was a subcontractor providing expert reports. But the reason she wasn't exempt was because she hadn't entered into a contract with the relevant German Social Security Fund. And we say what's noteworthy there at 51 to 52 is the court held that the refusal to grant Ms. E recognition as devoted to social well-being because she didn't have a contract with the relevant insurance body doesn't appear to breach the principle of fiscal neutrality. That was because well, again, taking from 51 and 52 of that case, what the court doesn't consider is whether the consumer of Mrs. E's services would have been influenced by the fact whether that she hadn't concluded a direct contract with the relevant Social Security Fund. So again, each time when you look at this specific way in which the court, in each of these cases on BG and H, has applied the Kugler, it sets out the Kugler list of factors, but then it gives an indication, obviously it's for the National Court to make the final decision, it gives an indication as to whether the exercise of the discretion is consistent with those factors or not. It finds in the Finanzamt D case, which is, as I say, at tab 43, at 52, that Germany was in principle within its rights to deny recognition because she didn't have a contract with the relevant fund, but it doesn't consider whether a consumer would have been influenced by whether it made any difference when she was writing her various reports, expert reports on the care and support needs of individuals, by the fact that she had not concluded a direct contract with the relevant Social Security Fund. And then the final two cases are EQ, and we touched on that yesterday, it's at tab 44. This is the case about the Luxembourg lawyer who had powers of representation for the protection of adults lacking legal capacity. That was the case about point G. The CJU gives guidance on Kugler, Dornier and King's Crest, the list of factors at 70. What the court then goes on to say at 83 to 86 and then 87 is that in order to determine whether a lawyer such as EQ was devoted to social well-being, one could take into account that his remuneration was determined under the supervision of judicial authority, and a number of other points. And what the court then said at 87 was that it was necessary to determine whether other taxable persons, including not-for-profit associations, enjoy similar recognition. And again, at 87, our point is the court doesn't ask the National Court to consider whether the consumer of EQ services would view him as a supplier, looking at the various factors they identify, such as the way he was paid and the degree of supervision, as interchangeable with a not-for-profit association, which the court mentions at 87. And then the final case is Mom Trade Ruse. That's at tab 48. And the issue in that case, it was a slightly odd case because it was about a Bulgarian company, which the question was as to exemption under point G, and the Bulgarian company provided care and home help services to elderly people, not in Bulgaria, but in Germany and Austria. So there was a sort of conflicts type question as to whether you look at who was entitled to exercise the King's Crest Kugler discretion. Was it Germany and Austria or Bulgaria? And the answer was Bulgaria, because it was a Bulgarian supplier. The court spelt out at 91 the same list of factors from the King's Crest line of cases, but it didn't refer to any further condition that the manner of carrying out the supplies or conditions had to be similar from the consumer perspective. And then at 96, in that case, the Court of Justice said that the registration of a company at a public body may be a relevant criteria. So again, it's looking at the national legislative framework. But the rhetorical question again is, why is it relevant if the court is saying that you can take into account the registration of a company is a criteria to take into account? Why is the Court of Justice saying that that can be taken into account, but then you have to look at the consumer perspective as to whether that's relevant? I.e., why can Bulgaria legitimately distinguish between care providers who were registered and inspected in Bulgaria and those who weren't, but then say, well, the recipients of care in Germany or Austria, because in that case the recipients weren't in Bulgaria, would have been influenced in their choice of care provider by whether the care provider had been registered and inspected in Bulgaria. Again, we say that that analysis at 96 of Mom Trade Ruse doesn't make sense from if one is applying the consumer perspective. In that whole list of authorities, there is one further one which isn't in the bundle, and it is referred a number of times. We do have copies of the one further case, which is Copygene, and I can just, again, give the relevant paragraph numbers.
Does it stand for anything that's different from what we've already seen?
A lot of it is dealing with other points. All it says is that A, you don't have to take into account all of the factors necessarily, i.e., just because the member state isn't required to exempt a body just because it's large, the services are largely refunded by the, for example, the social security authorities. The member state is entitled to take, for example, that factor into account, but it's not necessarily something which a member state is required to find as definitive. And also in that case, the court says, having regard to the principle of fiscal neutrality, the approach adopted by the tax authorities when they examine competing comparable establishments must be consistent. And on that point, Copygene's counsel confirmed at the hearing that there was no other private stem cell bank in Denmark. This was all about stem cells, the collection of stem cells from babies and then their retention in case the baby, when it grew into a child and then an adult, developed some horrific genetic condition. But that, we say that's consistent with our argument that that what fiscal neutrality requires is simply consistency in comparable situations. There's no requirement. That one also looks at the fiscal neutrality from the consumer's perspective. So the two passages I've just read out are 71 and 73 in that case. We have got copies, but the reference for it, if we can either hand them up or the court, if it feels necessary, can look at it. It's case C26208 in Copygene, and that's a judgment of 2010. But if it would assist the court, we can hand them up at a appropriate point. So that really deals with everything on the first point, except for I just wanted to make some very brief submissions then on how you apply that to I, and then move on to the other 2 points.
Are you going to deal with the decision of the Court of Appeal in life?
I will do in a minute, yes. That's really my final resting place. But my learned friend accepts, I can really counter through this as well. We say that the case law on BG and H must apply also to I, and there's 4 points here. First is the wording of the relevant exemptions. BG and H and I all have the same format, which is always governed by public law.
I think this is common ground.
And it's clear that the way that the court analyses matters, that one can apply by an analogy within the particular group of exemptions. The reference for that, and I don't need to take the court back to it, is Dornier at 72 and 73, where the court expressly endorsed Advocate General Cocotte at 55. So the court is at 72 and 73 on page 510, and the Advocate General's at 55 on 495, where she's pointed to the similarity between the substance of the various exemptions, in that case between B and G, and said you can apply by analogy, and the court agreed with her. So that's my point 1. Point 2, the court has already applied the case law in relation to the other 3 exemptions to 1321I, and the reference for that is MDDP, which again is at tab 35, page 724. And in MDDP, at the relevant passages 37 to 38, the court referred to King's Crest and Zimmerman, which were cases respectively on G and H. Or was the other way around, in fact. King's Crest was H and Zimmerman was... Oh, sorry, both King's Crest and Zimmerman were on G, and King's Crest also considered...
Well, I think, as I say, this is common ground.
Yeah. So we move on, then my third point is happy education.
Do you need this, though? These are all 4 points on common ground, aren't they?
Well, we're moving...
Sorry, I don't want to...
Yeah,
But
I know
time is quite limited.
I know.
So
the other 2 points, which I can just express very briefly, are we refer to the Dubrovian case, which is at tab 42. That's the one about swimming tuition, and my learned friend referred to it. We say that, I mean, this may also be part of the common ground point, which is that although the Court of Justice itself didn't deal with the supply condition, because it held that the swimming tuition wasn't a supply which was covered by the exemption, the German court, which was the Bundesfinanzhof, or the Federal Finance Court, so it's the Supreme Finance Court in Germany, expressed the view in making the reference that the supply condition, as analysed in point G, must apply by analogy to point I.
This is all common ground, Mr.
That's at tab 16. The final point, though, is happy education, which is, we accept that that's a post-2020 case, so it's of persuasive authority and not binding authority to this court. But we say that that is relevant because it goes beyond simply whether you can apply B, G and H to I, the common ground. We say it's interesting because and we'll possibly come back to this in relation to the second ground. Happy Education hadn't complied, that there was a specific exemption in Romania for after school education of children under what was called the school after school programme. And Happy Education didn't comply with the requirement of entering into a partnership with an educational establishment. And that's why it didn't satisfy, according to the Romanian authorities, the exemption. So this case is at, we'll see that at 932 and 933. And the CJU held at 35 and 37 that because Happy Education hadn't complied with the national requirement of entering into a partnership, it didn't qualify for exemption, despite the fact that it carried out educational activities in the public interest.
Yes.
So so not only did the court cite King's Crest in that case, you will see that at 31, and also it referred to fiscal neutrality, even though Happy Education Supply shared a similar feature with the education provided by state schools, which were bodies governed by public law, in that it was supplying education in the public interest. There was no suggestion in that case that the supplier condition, which was a partnership with an education body, was in breach of fiscal neutrality. So that reinforces, as far as I is concerned, that one can look at the national regulatory regime without reference to the consumer perspective in setting the criteria. And it's also relevant, we say, to the second point, because it would appear from that case that there was that there wasn't one single gateway or set of requirements for all non-public law bodies in Romania providing education. There was a very specific set of requirements for bodies providing after-school education. So that really deals with everything on point 1 except for the life case. I should just say that so that it's not thought that I'm avoiding any other authorities. We deal in our skeleton with ProMed and Fantasyland. That's at 33. Given time, we deal with our specific points on TNT at 32 in the skeleton, and Solivelt, we deal with that in our skeleton at 28. So taking as a cue the final thing on the first point in life, so we deal with that in our skeleton at 29 to 31. We accept. So on the second point, we say life actually supports us on point 2. On point 1, and this is at tab 22, we accept that life is not consistent with our argument. So that's the relevant passages are at 54 to 55 and 61 to 62. They're on pages 405 and 406. And you'll see at 54 and 55, the court, Lord Justice Arnold refers to the rank authority, and that's the only authority that's cited as far as fiscal neutrality, even though in this case the court was dealing with a supplier condition. One will see that there's copious reference to Zimmerman which we'll come back to at 42 to 49, including at 48 the passage of Zimmerman, which on the second point my learned friends rely on in support of their argument. But the only authority on fiscal neutrality is in fact rank. There's no further analysis of whether the rank consumer perspective applies to the supplier condition. And then at 61 to 62, the learned judge considers whether the relevant regulation in the life case made any significant difference to the consumer. And then refers to Solivalt and TNT. But in referring to TNT, what the court appears to be doing in that case is referring to the type of point in rank at 50, which is whether the regulation of the supply creates a distinction in the eyes of the consumer. I mean, the short answer to that is obviously the Revenue are aware of the position on the court in Young and Bristol Aeroplane and various other authorities, the limits on this court reconsidering decisions of previous courts of appeal. We've brought with us, as well as Bristol, the Young and Bristol Aeroplane case, a couple of other more recent authorities. There are 2 points there. One is that a second court of appeal, there's not an absolute prohibition on a court of appeal faced with a determination by a previous court in not following it in particular circumstances, including where the first court determines the matter per incuriam. In this case, the court has only, in fact, looked at on the fiscal neutrality point on rank. Which
Well, he does refer to quite a number of other cases,
but not on
including all of the cases we've been looking at today. He looks at King's Crest, he looks at Kugler,
BT,
Zimmerman, in fact, more or less everything that we've been looking at.
In the cases per incuriam, if the court is unaware of the relevant authority, you can't say that.
Yes. I mean, there is a second issue, though, which is that at the time when the point we're dealing with, so our case is actually a case that relates to supplies prior to 2020. So we heard from our learned friend yesterday between 2012 and 2016, I think, was the point. The issue here, though, is that regardless of what the position would be in the case of a Court of Appeal applying UK law, where the court is restricted to the Young and Bristol line of authorities, where the court is applying European law, at least in the period in which the UK was a member state of the European Union, which obviously we no longer are, but we're dealing with the tax situation in the period in which we were a member of the European Union, then the principles of the primacy of EU law apply. And therefore, the Court of Appeal is bound to follow the CJU, at least in cases where the Court of Appeal has a case in front of it dealing with periods prior to Brexit, and at least as far as the CJU cases were themselves made or decided before the UK left the European Union, i.e. in the period before we left, where the case relates to EU law and the relevant authorities were made by the CJEU before we left, then the UK Court of Appeal, or sorry, the Court of Appeal of England and Wales, is required to follow the CJEU and the guidance given by it.
But that's what life purported to do.
But if it's wrong on that, then if it failed to fully understand if the Court of Appeal in life failed to fully understand the relevant CJEU case law properly analysed, then the Court of Appeal of England and Wales in a further case, applying the first principles of European law, is required to apply the correct analysis in European law by the principle of primacy, i.e. It's bound to, which article it is, I think it used to be Article 5 of the TFEU, that member states, bodies, including their courts, are bound to uphold and, I'm paraphrasing here, EU law. I can quote it precisely after lunch, but the point is that obviously if the Court of Appeal in life was correct, then one doesn't need to worry about this because my learned friends are then right and there's no problem. But what if the Court of Appeal in life was incorrect with respect? What does this court then do? Does it then say there's nothing we can do about that? There's a previous decision of the Court of Appeal against you, Mr. Hill, and therefore you must go to the Supreme Court? Or does it, we say then, under the principle of primacy of EU law, if this court appreciates that a mistake was unfortunately made for whatever reason in life, then the principle of primacy means that if this court realises that the CJEU was telling the national courts, including this court, to apply a test which doesn't involve the consumer perspective to the supply condition, then we say you must follow the court insofar as you're applying decisions of the Court of Justice prior to 2020 to a situation where the relevant tax periods were prior to 2020.
Can I throw 2 points into that mix before we rise? The first is I think Lord Justice Jacob has suggested that there may be a further exception to Young and Bristol aeroplanes where there's a consistent pattern of decisions by the European Patent Office Board of Appeal. And the second is that I was involved in a case called Starmark and CPL, I think it was called, where this court held that a previous constitution of this court had misinterpreted a decision of the House of Lords and decided that they could revisit the question. And that would have been, I don't know, I'm not sure when it was, in the 1990s, I would guess.
Those are two matters I wasn't previously aware of, but we will, at least in the time we've got over lunch, we'll be able to provide the court with the relevant article of the treaty which we were once party to.
I would also find it helpful if you could identify which of the particular passages in Lord Justice Arnold's judgment that you accept are contrary to your argument.
I'll do that.
And also, do they form part of the ratio of his decision? Just get that basic building block sorted out.
I'll have a look. I'm grateful.
Right, we'll break now. Please bear in mind that Ms. Shaw and Mr. Blades need time for reply.
I do bear that in mind. I intend to be considerably, obviously there are a lot of building blocks to cover there. I've got about maybe 20 minutes, 25 minutes on point 2,
Yeah.
and on the final ground, Mr. Blaze.
Miss Inglis was going to do some of it, I think.
Yes, okay. I might be being over optimistic then, maybe half an hour. And then I've got a very short note on Mr. Blaze's argument. Without disrespecting it, we say that there are a couple of fundamental issues with his argument, and we can deal with those in 15 or so minutes.
All right. So that sounds as though you'll finish by 3.
Yes.
That should give you plenty of time for reply, I think. 2 o'clock.
Court rise if able.